How you doing, Jeremy?
Doing good, Adam. How are you?
Excellent. So let's have a conversation about the law and about what we've been doing since you've become part of this law firm. So, Jeremy, how long have you been with us? Maybe you can say.
Sure, Adam. I started here about 7 years ago. I've been a lawyer for 15 years, so about half my career has been this amazing firm.
So what's the origin story? How'd you come over here, and what brought you here?
Well, it's kind of a funny story because I actually saw you in court arguing a motion many, many years ago, and you did a fantastic job. I think you won the motion, unsurprisingly. And then one day I actually had a case that I was going to refer to you. Unfortunately, it was not a great case. I think you turned me down, but I always kept you top of mind. And then when I saw there was an opportunity to come here and work for you, I thought, hey, this guy's a really good lawyer. Would love to learn from him. Love to see what else I can do career-wise. And the trajectory looked really, really good. And then, here I am today.
I remember the hearing for the case in Kane County. It was a med mal case. It was a lap chole case. Got a greater result for the client. And it's funny. I didn't know you before that day, but I saw you and I remembered you. It's like an interesting situation where you see somebody and you just kind of remember them. But yeah, I remember the case you tried to send over here too.
It was a dog. I think it was a case with very poor liability, and I think you rejected me very politely, but at the end of the day, it wasn't a great case, and so I'm glad you did.
I think it was a dram case at a pub in Joliet, right?
It was a dram shop case, and I think it was combined with a slip and fall as well on top of that, so it made it doubly difficult to win. But yeah, it was a tough one for sure.
So you've been a lawyer now for, 14 years?
Yeah, going on 15 years this November.
So how's the practice been for you?
Practice is great. I mean, we love our clients. I love the clients we have here. It's really, really fulfilling and rewarding, representing people who are really, really hurt, at the worst stages of their lives and trying to get better. And as you all know, you handle, a lot of the most difficult cases here. And so it's just a blessing, let's just say, to be able to help these people.
So what made you become a lawyer?
So the reason I became a lawyer was because I was born in Naperville. I grew up in a wrestling family. We all liked competitive sports. Wrestling was kind of my thing. And I remember loving the challenge of, going after a guy just one-on-one trying to win it. And I think that's what kind of sparked my first interest in the law, where, when you're in trial, when you're in court, it's just you versus the other attorney. There's no one else helping you. It's your firm versus their firm, your team versus their team. And it's all trying to use your skill sets, your knowledge, your intellect to win the case on behalf of your clients. And that competitive nature really got me interested in trying to be a lawyer, because that's literally our arena, right? We're like in a wrestling match, it's you and the other guy in a mat. In trial, it's you and the other opponent in a courtroom instead. So I loved it, the optics of that, and it ended up being a great career path for me.
You and I have had many discussions over the years. We spent a lot of time together. And on my end, it's been just tremendously rewarding working with you and seeing everything that, that has been built and grown, and all the success that we've enjoyed over the last 7 years. There was I would say like kind of a similarity, number of similarities, but a similarity between how both of us were introduced to the law once we began practicing. I started the law firm. As you know, I started the law firm. I didn't have experience at another firm, and there was a little bit of trial by fire. I arranged for my first clients prior to being sworn into the bar. the day after being sworn into the bar, I'm going to court, and going to federal court, doing a lot of federal court, going to state court, doing a lot of state court, doing discovery, figuring that out, doing depositions, and honing and practicing and honing and building. And then what comes out of that is before long you're doing trials. I found myself being, in a spot where I'm doing trials at a really young age without a ton of experience, but I enjoyed it. It was totally thrilling, totally amazing, and it was, if I'm being candid, just a world-class opportunity to learn how to do a trial, learn how to do a case, figure out how to best represent clients. And once you've seen these cases from beginning to end numerous times, you've seen a lot of different permutations, you've taken cases to trial, and then you get that thing after the trial where maybe the jury gives you more than you asked for, or alternatively, one of my favorite things that would happen in those days, because, I wasn't, in the beginning of my practice, I wasn't trying the hugest cases. It was any case I could get to go to trial. This is like 2009, 2010. I'm 25, 26 years old, 2011. And, after the trial, the judge comes over, shakes your hand, and says, hey, you do a trial like that, you have employment security, put it that way. You know what I mean?
Oh, absolutely.
And the second that you and I were, starting to talk and, build our relationship, our friendship, and, everything we've done together the last 7 years, I could see the same in you, which was you went for it. You did those trials. You just did it. You did it in the same way. You did it probably even more than me in terms of like the number of trials that you did, maybe even a lot more. I was always impressed by that. And to do that involves fearlessness, courage, determination, it's just like a ferocity, And in addition to the ferocity, it's like, you picked it up. You learned how to do it. You became first a journeyman, then a craftsman, then a master. And I think, I've seen this trajectory for you, and maybe you can tell us about that, this journey that you've been on.
Yeah, no, absolutely. I'll be honest, when we met, I saw a kindred spirit because we did have a very similar upbringing as young attorneys. I remember when I first started practicing, I similarly was kind of thrown into it without a ton of training or a lot of any lawyers in my family or friends to really pick their brains on how to handle cases. But I remember my first trial was maybe 2 or 3 months after I got my first job, and it was a very difficult case, a dart-out case where a kid just runs out of a street and got hit. Driver had no opportunity to do anything to avoid this unfortunate child. I remember going into the trial, and I'll be honest with you, I got my butt whooped. I prepared, and at the end of the day, I remember the kind of saving grace for me, and the reason I'll always remember that trial is one of the jurors asked me for my card. And I was like, hey, I would have preferred a vote in my favor, for the victory, but the jury asked for my card and said, hey, thought you did a great job fighting for your client. It was a really difficult case, but at the end of the day, we thought you did a great job. And I think for me, that was kind of the impetus behind me wanting to try more cases and have an opportunity to really fight for our clients. And then when you and I met, I knew that you had a similar passion to really fight hard, to not take any offer thrown at us, and to make sure we represented people to the fullest, possible ability. And what I love about kind of the partnership we've developed over the years is that I've learned so much from you. I know you've learned from me at times as well. And it's been a fun journey, kind of just figuring out how to try cases together, how to win. And even in the cases where they haven't gone our way, we can rest assured that we did everything possible, spared no expense in fighting on behalf of the people we represent. So it's been a great journey.
There haven't been a ton that didn't go our way, to be honest.
That's right. There really haven't. But it's one of those things where you're given a set of circumstances, and you fight, till the end. And luckily, it has worked out very well for us.
When you came on board at the law firm, it was 2019.
Right before COVID.
So by that time, Zayed Law Offices had kind of evolved and I'd say elevated, where we were already back then being far more selective in terms of the cases that we would accept. And that's not that we don't want to help everybody. It's just we were trying to get involved in cases where we can make a difference. We had established our commitment to litigation. I remember you coming on board and you were watching me, how it would deal with insurance adjusters, which was essentially, sort of like, oh, you don't want to give my client a decent offer, you're gonna get that lawsuit filed.
I remember that. I distinctly remember that day you were talking to an adjuster, and it was such a bad offer. It was on a speakerphone, and I was in my office just kind of listening to you talk to the adjuster. And I remember you being offended on behalf of our client. The offer was so bad on a legitimate case where somebody was seriously hurt. I remember you slamming that phone and saying, I'm just going to file the lawsuit. You did file the lawsuit, and I believe we significantly won that case.
Back in those days, I think we were filing 80% of our cases. Now, the law firm has nearly 400 cases that are in litigation. All of these cases are cases where we're trying to represent our clients well, get them the best award possible, represent them with integrity, and, with honor, and to do a competent job. But I think that when you came on board, one of the things that I recall sort of working together on was giving these cases a lot more time to breathe. Like, I had a commitment, and I think that together we worked on this commitment where we were going to do all of the steps. We were going to prepare these cases. We were going to be more selective about the cases we would take to trial, be more selective about the cases where we could make big investments on behalf of our clients, e.g., millions of dollars, in experts, and doing everything that it took to work the case up appropriately. All the treater depositions, getting all the experts, the life care planners, the economists, anything that it took to put our client in the best possible spot. And I think there was I don't want to say learning curve, but I think that in the beginning you were kind of watching that, and it was a difference in terms of how it had been before for you.
Absolutely. I think one of the biggest differences that I noticed was when I came here, it wasn't just a bottom line. There were no bottom lines in trying to get clients' cases closed. There was not a need for quick resolution of cases. And what I realized here was that we were very selective as a firm in the cases we take. Basically, if we are taking somebody's case, it's because they were seriously hurt, injured, or obviously dying. And because of that, I realized that, wow, we've got to let them get the treatment they need. We've got to be able to provide them with life care plans to talk about their future needs, their loss of earnings, all of those things. And because of that, the cases we allowed to grow as necessary, and to maximize the outcome for the clients. And I have seen a lot of other firms out there that pretty much treat their clients like a mill, right? They're trying to just churn and churn and churn as many cases as possible, irrespective of how much that case is really worth, just so that firm can pay its overhead, its employees, et cetera. They don't really care about the client. It's just a number to them. And so coming over here, it really opened my eyes to taking care of the client on a personal level, right? Like really responding to their needs, making sure that their case was completely ready to go before it was resolved or tried. And that was definitely something I learned from you and from working here. And I think because of that, the clients that I've represented here have really enjoyed the benefits of that.
One thing that you and I, over the course of the last 7 years have been focused on is making sure that this law firm was an elite place, a blue chip place for talented lawyers to come on board and to not only grow their practice, but to work and grow as attorneys and trial lawyers, and to have the opportunity to try significant cases, to have a significant caseload, significant independence. Maybe you can talk about your experience in this way.
Absolutely. Working here has been phenomenal for many reasons. One, the ceiling is almost depthless, I guess, or heightless, for lack of a better phrase.
There isn't a ceiling.
There is no ceiling. Right. That's what I'm trying to say. So even now, you're helping me, trying to explain things. It's great. And that type of camaraderie and mentorship is something that a lot of firms don't offer to their lawyers. And to the experienced lawyers out there, there's a lot of autonomy here, right? You're not in an island by yourself. You have a team helping you, but you also have the ability to work your cases up, to represent your clients, and then also to get the help you need from other lawyers within the firm. And quite honestly, to any lawyer out there looking for good trial experience, mentorship, or even good camaraderie with experienced lawyers, this is the place that I would want to be. Not every firm out there, and I speak from just personal experience dealing with other firms as well, encourage their lawyers to try cases. Some of them, like I said, are willing to take the bottom line. They don't want to spend the money on the experts. They don't want to spend the weeks or the months long preparing for trial like we do here, right? I mean, so without a couple of the medical malpractice cases you recently tried, I know you guys were preparing for months at a time, sometimes even longer than that, leading up until the trial. And it is a time commitment, but I think it is a reflection of how much we care about representing the people that come through those doors asking for help.
I love your comments about camaraderie, and maybe I'll let you talk about this, but the team we have here is, I think, very nurturing, very invested in the future, very invested. We're all invested in each other. So all the attorneys here in this law firm are rooting for each other. And there's no jealousy. There's no pettiness. I think we're in this really cool spot where we have a core that is, we want more people to join us, but everybody is locked on and focused on a really, really bright future.
Oh, there's no doubt. Everybody here is part of a team. And I think that kind of goes back into the idea that we all understand our goal. Our goal is to win for the clients. Our goal is for Zayed Law to continue to thrive, right? And the team that we have here is very special. Everyone has a ton of experience trying cases, representing thousands of clients, I think, collectively, if not more. And just my own personal experience, I mean, there's been times where I've walked into your office, kind of stuck on a case, not quite sure what angle to go at. And next thing I know, it's not just you helping me out. There's 2 or 3 other attorneys who walk in willing to pour out their ideas and roundtable discussions on things. And next thing we know, we're doing real well on a case, right? And similarly, I know that everyone here has an open door policy, right? Sometimes we hit those snags. Sometimes we hit those challenges where we need help, we need advice. And everybody here is always willing to do that. And just from, personal experience, I know that there was a time, or any time, a lawyer here has, let's say a personal family matter, an emergency. Unfortunately, there's been tragedies as well. Every lawyer here is volunteering to help the other person out, to kind of cover for them at court, cover depositions. And you can't buy that type of brotherhood anywhere. Like, it's either there or it's not. And having been here for as long as I have, I can tell you that we've got a brotherhood here that, quite honestly, I don't think you can replicate very easily.
You know, I think it makes it fun to practice when you come to work. Everybody is engaged, wants to win. I think everybody around here is, what's the right way to put it? It's like we want to pass on the knowledge that we've accumulated. Like we're like, examples. Jeremy, you have become, I'm going to say, probably one of the top in the state, maybe the number one in the state, in terms of like certain tactics that you accumulated over your the trials that you put on, from when you first started practicing up until, when you came over here, because you had some really rough cases, and you kind of you won those cases based on tactics. A lot of them, like you would spot the weakness in the defense. You would spot the procedural weakness. One thing that is not to be underestimated with you is that the Illinois Rules of Civil Procedure, Illinois Supreme Court rules, you've been practicing now for 14, going on 15 years, but you know them cold. So every once in a while, there's that little procedural rule where it's like somebody's trying to pull something. You pull out that rule out of the back pocket. It's like, no. Here's the rule. You know what I mean?
No, the law's there, right, to serve the people, right? And I think one of the shortfalls that a lot of people who are going into trial practice don't realize is that you can use those rules as a sword or a shield, right? And I'd rather use them as a sword. And my father used to tell me growing up that action is faster than reaction, right? It's easier to attack as opposed to defend, right? If you're walking down the street, you expect somebody's going to attack you. It's it's harder to block, right? To anticipate what they're going to do. But when you're on the offense, as plaintiffs' lawyers have to be, you've got to be ready to attack. Every aspect of the defense's case. You got to look for those holes in their armor, right? You have got to look at the weaknesses in their defenses, right? And I've tried some really, really tough cases, like you said. I tried a case one time where there was a fight at a cemetery between all Chinese-speaking seniors. And it was one where nobody knew what was going on. The entire trial was in Chinese. It was very difficult to explain to the jury our theory of liability as to why our client, was punched out by another senior citizen. But, we were able to pull through in that case by knowing the law, knowing the key components of the case that the jury had to evaluate. And they did the right thing by following the law, and they came to a favorable resolution for us. But it's not always easy, but it's so important to know, as you know, because I remember you told me, I think you remembered, every rule of civil procedure out there. And that was, I think, one of the funniest things, because I remember I did the exact same thing, as a lawyer growing up.
It's funny you say that. When I first started practicing, I would just, maybe this isn't the best way to do it, but I would just read the rules of civil procedure, read the Supreme Court rules, go back and read them again, because you need to know those, and you need to know the court rules. You need to know the local rules, especially in federal court, especially if judges have local rules that are significant in state court. So I would pore over those. And back in the beginning, I didn't understand the leniency that the judiciary had to people who didn't know the local rules. I was like, look, we learned these things. Let's pay attention to them. Let's use them and be bound by them if they're going to be the rules. As the practice has gone on, I guess I'm less of a stickler. You have thoughts about this?
Admittedly, I think as time progresses, it is easier to forget those rules. And I think one of the reasons why I think me and everybody here likes trying those cases, because it helps you keep that memory sharp. It's easy to forget some of the nuances and different trial techniques if you're not in the courtroom using them. kind of like any skill. If you don't practice, it's easy to forget or lose that muscle memory. And it's the same way with the rules of civil procedure or the Illinois Supreme Court rules. You got to constantly be, diving in. And I think that's why I think we enjoy, the fight, right? Get that muscle memory, the legal muscle memory going and keeping it sharp.
I mean, you've been up against an opponent who didn't know the rules really well. I take it.
Yeah, there are plenty of lawyers out there who don't know the rules, and unfortunately, I think they're doing their clients a disservice by not knowing, the rules that are being used against them. But I've never seen that from one of our attorneys. That's never going to happen. I think all of us make a 100-fold effort to make sure we're on top of that every time we're at trial, especially.
We take pride in what we do, and we enjoy it a lot. How about but back to my earlier point. What I wanted to say was, we are all trying to kind of grow the collective knowledge. I think we're all invested in this law firm being a platform for the biggest cases, to be able to go to trial at the highest levels, to work on the cases with the highest stakes, to represent ourselves, represent our firm, represent our clients well at court. And in our earliest discussions, I remember them very well. We were absolutely on the same page, absolutely committed, and that commitment is only stronger now. Committed to just trial excellence, working on the biggest, best, most interesting cases. It's like a vocation, yes, success is great. And the complexity of the law is great, but at the end of the day, we want to work on the biggest possible cases. We want to go to trial on the biggest possible cases and represent our clients in the biggest possible cases. I think that over the course of time, we are continually raising the bar for ourselves, the complication, the sophistication of what we're doing. And I think we're in this really sweet spot where the trajectory, our personal trajectories, our legal trajectories, the trajectory of the firm is in this really cool direction where, kind of our dreams and aspirations have come true and are coming true. We're taking on the world,
Yeah, no, I feel like the complexity of the cases we've had has only grown and challenged us to also grow with the complexity of the cases themselves. I've noticed that the experts that we've retained, we've spared no expense for our clients in hiring the best experts that you can possibly find, and those who are genuinely supportive of our cases. And I've only seen that happen more and more and more as the cases become stronger, more complex, and as we're trying to, as you said, achieve, the dream and continue to chase after that dream of becoming, the best out there. And so it's been a fantastic, journey in that sense because, and I think kind of to circle back to your earlier point, if there are lawyers out there looking for challenging work, fulfilling work, and, meaningful work, this is obviously the place you're going to want to be because we're continuing to climb that ladder.
We had trial heroes when we were younger men, and it's been absolutely amazing growing the law firm and putting ourselves in a spot where now it's us who are going up and handling some of the biggest cases. And, accumulating the expertise. You're not allowed to say you're an expert as an attorney in Illinois, but accumulating the expertise and experience to be able to handle these cases, to represent these clients. I'll say the following. Our firm has never lost an appeal. I think, we just we are remarkably successful at those appeals. And why is that? Because we know the law, you know? That's one. Two, in terms of medical malpractice cases, I mean, maybe there are some firms in Illinois who have the medical malpractice cases that we have, but I honestly think that we, in terms of the volume, numerosity, we are probably working on more medical malpractice cases than just about anybody. The number of very significant catastrophic cases that we're currently engaged in is huge. Like I said, we're nearly 400 active litigations. That means filings, you know, cases in court where we are taking the depositions, doing the discovery, working with the experts, getting the case ready for trial. It is, it's kind of funny to some people, working on like a litigation caseload like that would be, I guess, quote unquote, stressful. You know, I think for you and I, this is the happy place. Like coming to the office, working on these cases, dreaming big for our clients, trying to get the recoveries that they deserve is like a day on the golf course. It's what we want to do. We're doing the work we want to do for clients. I say this all the time, but we rest really easy with the work that we do and the quality of the craftsmanship that we do. The reputation that we've been able to develop, you know, like it's just been such a pleasure doing this with you over the last 7 years, Jeremy.
I mean, we've had a lot of great battles together, and this is my happy place. When I'm in a file, litigating that file, taking the depositions, when we're strategizing together on how to take down, you know, our opponents, that's kind of where I feel the most in the zone. I don't have a problem sleeping at night, any night, just because, you know, by the time I'm, you know, done at the office, you know, I'm mentally drained. But every night I go to bed knowing, you know, hey, we fought hard, we worked hard, and quite honestly, it's all going to pay off in the days ahead. And it has been paying off. You know, as you know, we started, when I started 7 years ago, I remember us starting that fight then, and we're still fighting now. And I see it, us fighting for, you know, another 20, 30 years together. So it's been a good journey for sure.
In boxing, there are the different weight divisions.
Yeah.
Lightweight, welterweight, and then there's heavyweight. This law firm is in the heavyweight division now. In terms of the cases that we take on nationally, in terms of the cases that we take on in Florida, where, you know, our offices are located, in terms of the cases that we take on in Illinois, you know, it's just a remarkable success story. And I think that one thing that gives me great pleasure is knowing that our best battles, our best work, the most fun that we're going to have is still in front of us. You know, like you said, 20, 30 years, that's one thing that you and I have always talked about. 20, 30, 40 years, whatever it takes, man. Growing, taking on the biggest cases at the highest level, and being legal heavyweights, you know?
Yeah, it's not easy. It's definitely not easy. I mean, you've done a fantastic job leading all of us in that direction. And I can confidently say there's not a doubt in my mind that, you know, we're going to be the Mike Tysons, you know, of the United States here, right? It's already starting to happen. The sheer types of cases we get in, like really good, really, I mean, unfortunately, catastrophic for the clients, right? I mean, these are cases that require a lot of fighting to do, but, you know, luckily all of us are still in our prime, I'd like to think, right, or at least getting there, and got many more years left to fight. But for sure, I mean, the reality is that the personal injury landscape, the medical malpractice cases, they're not going to stop because there's a lot of human error out there, you know, and when that happens, you know, these people who are injured or hurt, they're going to need lawyers to fight for them. And one thing I can confidently say with 100% certainty is that we will always be there to fight for them.
Jeremy, let's do fact or fiction.
All right.
If a witness lies on the stand in real life, how often does the attorney immediately expose the lie in the way it happens in The Lincoln Lawyer or Matlock versus discovering it much later?
It actually happens quite often. I mean, the key to anything is preparation, right? As the lawyer, it's your job to know when that witness is lying. That's why we take depositions. That's why we do discovery. The idea is to figure out what the witness is going to say before the trial even happens. So if you're ready for it, you should already know that the witness is lying and then confront them with their prior deposition transcript and show to a jury that this person is lying. So it does happen quite often.
Yeah, I mean, I can't think of a single witness. I mean, maybe it's happened one or twice, but this process is called impeachment. So usually what I do when I'm preparing for a witness at trial is I contemplate what I think they will likely say, because they're bound by their deposition transcript, to a degree. I mean, you'd be remarkably surprised how frequently that defense experts say things that are just not consistent with their prior deposition. It's like kind of like the basics. But notwithstanding that example, usually I try to anticipate where I think somebody will, where they will be forced to fabricate something. And then if, one, they say something that's not consistent with their deposition, because it serves them, or alternatively, I think that they're likely going to fabricate something, usually I have some ammunition ready to confront them. And you have to make sure you can get it into evidence. You have to make sure that, or be able to use it. Most recent trial that is fresh on top of my mind is, an expert that just couldn't testify consistent with his report. The reason being, the defense attorneys drafted the entire thing, and it wasn't consistent with his actual opinion, which, really exposed that expert. So I would definitely, I can't say that I've seen what was it? Or the show's Ally McBeal.
Matlock and the Lincoln Lawyer.
I never saw Matlock, but it was kind of like on the periphery when I was a little kid. Like when you're flipping through channels. But yeah, you confront them in the courtroom. You agree with that, Jeremy?
Yeah, absolutely.
Can lawyers really walk up to a witness unexpectedly and aggressively interrogate them like TV and movies have portrayed, or are most questions heavily planned and limited by procedure?
Are you talking about like out there in the world, can an attorney go up and talk to a witness, or are we talking in a courtroom?
In a courtroom.
Well,
Correct, Justin?
Okay, well, you're with the champion of attorneys who's an absolute master at talking to witnesses outside of court, which is totally ethical, totally appropriate and acceptable. Jeremy, maybe you have some thoughts about that. We'll change the question up a little bit.
Yeah, so the law does allow you to talk to witnesses as an attorney. Now, if that person is a defendant or the other side, you're not allowed to talk to that person. But if we're talking about witnesses who observed an event, an incident, you're more than able to talk to them. Now, the key is trying to get them to talk to you. There's certain things you can do to kind of entice them or cause them to be willing to talk to you, which is helpful at times to know how to do. But yeah, you can absolutely talk to witnesses at any time you want, as long as they're not represented by your opposing counsel.
This comes in particularly handy in a slip and fall case, or a premises case, or a motor vehicle crash that's contested, where there are going to be witnesses who are not represented by anybody, and they have information that is valid and important to the case. I mean, you could go so far as to say that it would be, at best, poor practice not to talk to these witnesses. At worst, something akin to, I almost want to say malpractice not to talk to these witnesses if they're going to have relevant information that affects the case, affects your client. right?
Yeah, I mean, I had this wrongful death case a long time ago where my client was unfortunately killed by a bus. And there was one witness who I was able to locate. And that same day, I drove out to meet with him. And he was willing to meet with us. And I got a recorded statement of his observations. And that pretty much sealed the entire case for us afterwards because we were able to get his testimony locked in so quickly. So it's really important that you do talk to the witnesses. I think any good lawyer would.
And then in the courtroom context, I mean, if a witness is on the stand, sometimes it can get pretty heated in the courtroom. Now, that can be a tactic. What does a lawyer want to achieve by aggressively interrogating or conducting an examination of a witness? You can push it too far. Or alternatively, maybe some pressure is required to try to put the witness in a position where they actually just tell the truth. I think a lot of attorneys have that a few good men moment where we're looking for an epiphany from a witness. Sometimes that's not the best approach. Sometimes it's probably a superior approach to present a witness with facts and reality and let them seal their own deal. You ever thought about that?
No, I think you're absolutely right. Those a few good men moments don't come as often as we'd like. I know that it'd be amazing if they did, but you're right. Sometimes the strength is in the subtleties of the examination, or getting them to admit things without them even realizing they're saying something that will end up helping you and be damaging to their case. Completely agree with you.
I honestly can't say that I feel like I've generated a lot of a few good men moments, especially with defense expert witnesses, because a lot of these individuals just, their story breaks down when confronted with facts. But I sometimes I'm becoming of the mindset that if you go at them too hard, it takes it out of the jury's hands, and ultimately it's the jury who has to be the decider. But I kind of view it as our goal to serve it up to them. So it's a complex, nuanced situation.
Yeah, I think the unfortunate part is sometimes juries are composed of men and women with different feelings as well, and the irony is that sometimes if you attack a witness who's caught lying too aggressively, sometimes you risk the jury actually feeling bad for that witness. As I'm sure you've seen from time to time as well, like whether it be a defendant, maybe not so much in the expert medical malpractice case, but sometimes if you do go at a witness too hard, it can backfire.
Or, the jury feels like the defense has been punished enough.
Right, yeah. They view that as their punishment. That's correct.
Next question, please.
In real trials, do attorneys object to preserve the record for appeal as often as TV suggests, or are many objections made more for jury psychology and courtroom control?
What's your thought about that?
I think it's a combination of both. There are defense attorneys who will object to preserve an issue on appeal, which you have to do or you waive it. There are also defense attorneys, or any attorney for that matter, who will object to obstruct the flow of another lawyer's questioning. So, for instance, if a lawyer is on the examination, if a lawyer is cross-examining another lawyer's client and is scoring, hit after hit after hit of information that's favorable to that person's case, the other lawyer might be throwing 1, 2, 3, 4 objections just to impede the flow of that testimony. It can be effective, but it can also be detrimental as well. If you do it too much, you just look like an obstructionist, right? But if you don't do it, then you risk a jury just completely, being sold on that witness's version of what happens, and your case could be tanked as well. What about you? What do you think, Adam?
Usually, I'll begin a trial where I'm not going to object a lot. And I'm not going to go in there strategically to object, to obstruct the flow. because I do think that the jury can hold it against you. I don't think that that's it's not like the end all be all. But I mean, the biggest form of objections are, like when there's a motion to eliminate or, like an obvious principle of law that the defense is either intentionally going to wade into to test the waters, or alternatively, sometimes just kind of like haphazardly is going to go into that area. And you need to put up that boundary to make sure that we don't get into this information, like maybe a client's prior injury or something like that. And you need to do that for several reasons. One is to preserve the record for appeal. Another one is, despite there being a motion to eliminate, despite there being some principle of the law, if you don't object and the defense gets into it, the judge could easily say, hey, you know what, you didn't object. Now the door's open to this. But sometimes there's a situation where the defense is objecting a lot. And, maybe you get into a spot where, okay, I need to be more proactive about the objections that I'm going to be using here. I've had trials over the course of the years where, the defense won't even state a basis for their objection. And it's just objection. That's always interesting when that happens. But generally speaking, when I object or one of the members of the team objects, I like to make sure that we're, making an objection that is actually going to hold up if this, was subject to an appellate review. So you state the objection, and then your succinct basis why, and then you have to test as to how the judge is going to not only rule on objections, because sometimes judges don't really want a lot of objections, and they make that clear. But sometimes, you can get a little more latitude with a speaking objection. And, those can be used and kind of saved in the back pocket just for that circumstance where, let's make that speaking objection, I won't state the reason why you do that. But Jeremy, you have thoughts about that?
No, I'm of a similar mindset. I prefer not to object, to obstruct either. And I think the reason why is because the juries are smart too. They know when you're trying to pull something, if you're trying to stop a witness from saying something that might be crucial to the case. Now, kind of circling back, when you talk about motions in limine, we're talking about agreements that the parties have with the judge before the trial starts, that you're not supposed to do certain things, like say X, Y, or Z. And I've been in trials where despite having those agreements in place or rulings by the judge, some defense attorneys will violate that anyway. And it's at that point where you really have to jump in and remind the judge, hey, this was already decided. You can't say X, Y, or Z. It's going to prejudice my client. And those are the moments when you really have to be astute and be on point in getting your objection out there. Because sometimes there are people who will do anything to win. They'll cheat. They'll break the rules. And I've seen you actually on trial in cases where defense attorneys have tried violating motions in limine that were ruled upon that could have been critical and very detrimental to your cases.
Both you and I think everybody in this law firm, we have a lot of respect for the court and for the judiciary and for the staff in a courtroom. We are, by nature, wired to go in there with a lot of respect, And I think when we see opponents that are going to violate that motion to eliminate, that are going to push those lines, going to push those limits, we need to rise to the challenge. It's kind of like, if you watch like a Rocky or something, or a movie where somebody takes a cheap shot, we're not going to be the ones that are taking a cheap shot. We don't take cheap shots. But during the course of a trial, we're probably going to take a cheap shot. The question is how you're going to handle that. That's an important part of trial advocacy. So we can go on to the next one.
Okay. How common is it for attorneys to discover the one key witness at the last minute the way they do in courtroom thrillers, compared to reality of months of years of investigation.
That is not consistent with reality. So we have discovery deadlines where we have to disclose F1s, which are lay witnesses. We have to disclose F2s, which are independent expert witnesses. Those are like treaters. These are experts that are not under the control of either party. And then there are F3s, controlled expert witnesses, meaning retained experts that each side will retain in a trial. You, as an attorney, you must disclose them on schedule, on time, to give the other side ample opportunity to depose them and to conduct discovery. And the objective in civil cases is to avoid surprise. So there are no surprises for the other side if they've conducted ample discovery, or the surprises are minimal. That being said, I will say that I have had situations where the defense, on the eve of trial, files a motion to add new experts, and the judges didn't take kindly to that, because that's not something that happens in a civil courtroom. Jeremy, you have thoughts about that?
Yeah, I haven't had any experiences where a witness was disclosed on the day of the trial or the eve of trial. Fortunately, Illinois has safeguards against that type of surprise. But I have had also cases like you where maybe a month or two before the trial, a surprise witness or two will pop up out of nowhere, and the defense is asking the judge for permission to disclose that witness, despite us vehemently objecting. And it can roll both ways. There are judges who will sometimes allow that and say 2 months is adequate time for you to learn what this witness is going to say. And there's some judges who will say absolutely not. Unfortunately, as trial attorneys, we've got to roll with how the courts rule. Sometimes it may seem unfair, but that's the whole point of trying to adapt and figure out how to address these sudden ambushes, so to speak. But I think we've all had experiences like that.
It's kind of funny. Like, a couple comments. One, when you're preparing for a trial, it might take 2 or 3 years. So you're 2 years away from trial, and you get a new witness disclosure, or the defense updates their F1s, and it contains this new mysterious individual, and you're scratching your head, like, who is this? Who is this person? Sometimes it's totally benign. Every once in a while, there's something that's of importance. You need to make sure you're looking at those disclosures. And people are very meticulous and fastidious over all of the witnesses that are disclosed. But that being said, when you get on trial, it's funny. When you get on trial, like a different mode happens where whatever comes at you, whatever witnesses, whatever experts, you have to be able to roll with the punches. You have to be able to you have to be ready and willing to handle a lot of variability in terms of who the defense might call, in terms of who you might call, or in terms of which witnesses commentary or testimony is invalidated because of the way that the ebb and flow of trial went, or maybe a judge strikes a witness and doesn't allow you to present them. And just one thing I'd add is that I always heard these stories. Maybe you did too. Because I think the Civil Practice Act was passed in like 1985, 1986 or something like that. I think that's what it's called. So Jeremy and I, we're kind of contemporaries in terms of age. We grew up with the Illinois Supreme Court rules, the Illinois Rules of Civil Procedure. There was a time, as recently as the 80s, where there were no rules like that. It was all based on case law, like rules of evidence and procedural rules in the case law. They didn't have rules of civil procedure, They didn't have, these laws and statutes that were in the firmament. So back then, my understanding is that, 1982, 1983, you could show up to trial with new witnesses that day. You could, it was kind of like the wild, wild west. And we look back at how we began practicing law, and that seems like the wild, wild west compared to how it is now, where, we would go do trials as, very young attorneys. But I can't imagine what it was like back then. Your thoughts about this?
I can't imagine practicing in a day and age where witnesses didn't need to be disclosed. But, I mean, you're absolutely right. That's how it used to be. And you and I think have both run into attorneys who've actually were practicing during that time where, it was literally the wild, wild west, like you said. You just roll up the trial with, a wagon of documents and then try your case.
And maybe like a new witness or two in tow.
Right.
You know what's funny is every once in a while, these attorneys are, I see them less and less, but every once in a while, back when I was first starting, 10, 15 years ago, I'd run into an attorney who was like 80 years old, and they thought that the rules of civil procedure were like this newfangled thing, and they're trying to run a case like it was 1979. I'm like, whoa. We have rules here now. You know what I mean? Anyways.
Okay. Do prosecutors and defense attorneys usually have personal friendships and casual relationships outside of court, like in Law and Order, or is that exaggerated for storytelling?
From what I've seen, I think in general, there are relationships between the attorneys because they see each other so often. I've handled a lot of cases, obviously, in the civil realm, but from what I've seen of the criminal realm as well, the prosecutors and the defense attorneys do generally know each other because, once again, they're clashing over and over and over again. What do you think, Adam?
I think so. I think that there's an opportunity for friendships to occur between plaintiff and defense attorneys. And sometimes there are individuals who are kind of zealots. I think maybe they're not as good a time. I don't know. I find that the attorneys that we do trials with, we end up sort of, having a kinship or maybe a mutual respect of some kind, especially if the trial was conducted with integrity. That being said, if we filed an appeal and won, usually we don't end up being friends. Yeah. D, go ahead.
Okay. How realistic are courtroom confessions where a witness or defendant suddenly breaks down and admits everything in front of the jury, as it seems as seen in countless legal dramas?
I have not seen that. I have not seen the mea culpa. I have not seen the facade break on the stand in that moment. I've seen moments like that in a deposition, or close to it in the deposition, or maybe the intent. An intent like that in the deposition where people want to admit that they did wrong, but they go just to the line. But at trial, I think that the decorum is such that, people hunker down. You have thoughts about this?
Yeah, I think in the shows there's that added element of drama. You're trying to appeal to the audience, whereas once again here at the trial, everything has already been hashed out in discovery. So generally speaking, you already know what everybody's going to say, or you should know if you took their depositions. But to your point, I think you're right. In the depositions, that's the phase where you really get that aha moment, like, or the I gotcha moment, and then you just bring that out at trial. So you're going to have that aha moment or I gotcha moment usually before you get to the trial because of what they said or what the witness said in the deposition.
Yep.
What's more important in a real jury trial, mastering legal procedure and evidence rules, or possessing the kind of charisma and improvisation celebrated in movies and TV?
I think you need both. I really think you need both. You must. It is absolutely a prerequisite to know the rules of evidence, to know the rules of civil procedure, to know the Supreme Court rules, and you're going to be doing yourself and your client a disservice if you're not able to show respect to the court and to the jury. I have seen successful trials happen with attorneys that I did not think were particularly charismatic, but they knew the rules. They didn't even need to prepare that much. But they knew the rules and they were present. So I've seen that happen. I think at our firm, it's absolutely required that we're masters of the rules of evidence, the rules of civil procedure, and the Supreme Court rules. There's some room for, different interpretation. We have an interpretation. I think we view the law as good and big and just. And I kind of view the law as, I don't want to add an unnecessary personification, but it wants to make our clients whole. That's why the law is there. That's where my interpretation of the law comes from. I think charisma is nice to have. I've seen people who are, they don't seem charismatic to me, but other people might think they're very charismatic. But then that charisma wane during the course of the trial, and at the end they're kind of like a puddle of mud on the floor, because their deceit was uncovered. I've seen people who are full of themselves. I ultimately, this human experience is full of subjectivity. So someone thinks that they're charismatic. Not everybody does. Somebody thinks they're not charismatic. Some people really like them. There's a lot to that. But ultimately, I think the fundamentals are absolutely important here, like they are in so many different arenas, whether it's sports or whether it's other professions. You have thoughts about that?
No, I agree. I think that both being charismatic and being knowledgeable of the rules of civil procedure, the Illinois Supreme Court rules, are absolutely necessary to be a good trial lawyer. Now, there's different degrees of both, but I think the most important thing is you don't ever want to lose your credibility with a jury. I think having a lack of personality, having a lack of knowledge can both be damaging to your credibility as an attorney, right? If you have no charisma, I think you're boring, you don't know what you're talking about, or you have no conviction in representing your client, right? Conversely, if you have no knowledge of the rules, like you said, you have no ability to articulate what the rules are, then sometimes you run the risk of looking foolish in front of a jury as well, because the judge is constantly ruling against you. But to your point, I've seen someone who was super charismatic just flop in front of a jury because they didn't know the rules. And I've seen a couple attorneys who were really, really smart, knew the rules, but they flopped in front of a jury because they had no personality, no substance either. I think the jury was just kind of bored or just disinterested in what that person had to say. So there's definitely a balance, like you mentioned, that you need to have in order to try a case. I think TV tends to do over the top with charisma, but that's because they can't slide in the knowledge component, in a 30-minute show.
Yes.
In real life, can lawyers object every few seconds the way they do on TV, or would judges quickly shut that down?
Lawyer can object as much as they want. The problem is you run the risk of looking like a fool if you're objecting to things that make no sense. And I've actually been in a situation like that. When I was a younger attorney, there was an older attorney who would object to almost every question I asked. And these were very simple questions. For instance, like what color was the light when you first saw it, right? And he was throwing out baseless objections. I think the jury could tell he was just trying to be obstructionist. And what I did was I just asked the jury or the judge, I had a sidebar with the judge and said, Judge, if he's going to object, I need some real objections. And the judge actually did caution this attorney into, leveling appropriate objections. So sometimes the judge can serve as a good referee in cases like that.
I'll add some comments about deposition strategy. Now, in the state of Illinois, relevance is not an appropriate objection during the course of a deposition. And foundation is also not an appropriate objection during the course of a deposition. Because imagine this scenario where a okay, well, let me go lay the foundation of things that are in evidence. Let me go lay the foundation for this question in a deposition. You don't need to do that. You're inquiring about things that are potentially relevant. So when I'm in a deposition, and I've seen it happen a lot, especially with, I think younger attorneys, the depositions that I hear over and over and over and over, and I think that, I've had depositions where there are 160, 200 objections. I mean, this is potentially sanctionable conduct. And the objections are objection relevance. It's like, let's say this is an example. These weren't car crash cases, but it's like, so you were driving down the road, and when did you first see the defendant? Or when did you first see the plaintiff? I'm sorry. And then the defense objects, foundation. I'm like, what do you expect? What foundation are you looking for? What foundation are you talking about? You want me to go bring in a police officer to lay the foundation? You want me to go bring a police report to lay the foundation? This is like knowledge that is exclusively and distinctively in the mind of the deponent. It's an absurd objection. And you made 200 of them all over this deposition. You made a mess of it. You accomplished nothing. All you did was show me that you don't know how to do a deposition. So that's always interesting. I mean, I think that, the right way to do a deposition is not to be a unreasonable obstructionist. But that being said, people who make objections like that, I don't think that they're going to have success being an obstructionist, even if that's their intent. You've thought about that?
No, I think the most dangerous attorneys I've gone against are the ones who kind of sit back in your deposition. They'll object to the important stuff that, most people would object to, but they sit tight, kind of let their client do what they've got to do. And the reason why is because that defense attorney already prepared their witness before that deposition even took place. They don't need to object. They already know what their witness is going to say. They have them so prepared that there's no need for them to object. I think that's the mark of a true good trial attorney. And the reason I say this is because when you see them at trial, the way they can articulate their questions, the way they frame them, they do it in a way that is consistent with that deposition testimony that was already, their witness was already well prepared for. But yeah, I mean, whenever I walk into a deposition and there's, a million objections in the first 20 minutes of the deposition, it generally is with the younger, more inexperienced attorneys, unfortunately, as well.
There's a movie. I can't remember what it's called. I think it's called A Civil Action with John Travolta. And John Travolta is the plaintiff attorney. The defense attorney is played by Robert Duvall. That's one of the legal, forms of media that I've consumed over there. Robert Duvall is giving some tactical advice, and he says, object, 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 and then object. During the course of the trial, he's the defense attorney for some big environmental polluter. He falls asleep, and someone nudges him, and as he awakes, he says, objection. I think that some people have that strategy. That's usually not what we do. But, maybe he trained some of these people that we see in these depositions.
All right. How often do real attorneys deliver emotional closing arguments that completely change a jury's mind compared to the dramatic jury turning speeches seen in My Cousin Vinny or To Kill a Mockingbird?
Thoughts about that?
I think that in general, closing argument is the time to appeal to the jury. It really depends on the circumstances of the case, right? It's just, if you're representing a young person who passed away through the fault of the defendant's negligence, right? You're going to want to appeal to the jury, right? You're going to let them know, hey, this is what this person meant to their family, to their friends, to the community, right? That's naturally a very emotionally compelling situation, right? Whereas in other cases where the injury is less severe or the circumstances are less dire, right? There's no point overselling it because the jury's going to think you're just trying to manipulate them, right? And there's no need for that. It's really just laying out your case, letting them know, hey, this is how this injury or this circumstance has affected that person, and it is what it is. But I think there's a time and a place, but not every case is a lightning rod for very emotional, tear-jerking closings. What do you think?
You don't want to take it out of the hands of the jury. You don't want to take the wind out of their sails. I've heard this aphorism and I really like it. And sometimes I go overboard because, you can get caught up in these cases. Like you prepare it, you go through law school, you want to be a lawyer. Doing the closing argument in front of a jury is the pinnacle of what a trial lawyer does. It is thrilling, but it's not entirely about you. And it's about the jury and how they view things. I think that I think that there's this like interesting dynamic where if you don't give it enough gas, the jury is gonna think you're disengaged and not really like it. But if you go at it too hard, then you can run the risk of taking it out of the jury's sails. So that's my thought.
Agreed.
What do you like best about being a trial lawyer?
The best part of being a trial lawyer is trying cases for me personally. I do love trying the cases, but more importantly, I love the relationships that come along with that, like getting to know people, getting to help them in their most vulnerable states. It's really life-changing, and it can be life-changing for that person as well. So to me, there's nothing better than working in a field where my job is to help people in an arena like a trial where it's constant competition, basically battle of the minds, the wits, and knowledge of the law.
When I first started practicing and doing trials, I was doing them myself. As time has gone on, I've really come to enjoy the team component of doing a trial. So somebody who's working on motions, somebody who's presenting some witnesses, maybe doing voir dire, maybe doing opening, maybe doing one component of the trial. And that also takes some of the load off of you if you're engaged in the trial, so you don't have to do every single thing every day. Also, there's a component where, during the course of a trial, a jury can get fatigued of a lawyer. It kind of gives the break, mixes it up a bit. I love watching the members of the team thrive in a courtroom, excel and rise to the challenge of this battle. I love the teamwork, love the camaraderie, and then most importantly, our clients have one shot to be made whole. One shot to be made whole for what can be life-changing injuries, maybe terrible, catastrophic injuries. And to be able to represent clients at a courthouse, in a courtroom, orchestrated by a judge and a staff that is funded by the community, because this needs to happen for the benefit of the community, for the benefit of the geographic area. Justice needs to happen. The person needs to be made whole, and they need to be made completely whole. And, if the defense decides to send them home with no money and no compensation, so be it. But we're there advocating for this individual, doing everything possible within the law to make them whole. The law wants to make them whole. The court is there to give people an opportunity to be made whole. It's a societal function, and I'm incredibly proud and always have been to be involved in that. So I love being a trial lawyer. I love representing clients. I love working with my team.